Still with us we have two different criminal defense attorneys, Jack Rice, Mark O'Mara. Let me start with you, Mark. Really listening to this, it's tedious detail. And A, do you think that the point's clear what they're trying to accomplish? And B, is there any way around having to present this tedious detail sometimes if you're making allegations of fraud or misuse of a vehicle?
Yeah, I'm not sure that they need to spend a lot of time on these counts, unfortunately. You know, granted, judges are more used to tedium than juries are. Juries get bored a lot quicker. So I guess this judge is just biding his time, listening, knowing the elements have to be made. But in the same sense, they can sort of rush through this a bit. They have a judge who's done this for a while. It's pretty obvious what was happening, and I think they could probably short circuit, save the judge some time to get really into the counts that they want the judge to focus on. Of course, the more, call them emotional counts of what he had done that they're alleging he did wrong.
Yeah, no, there were a lot of emotional witnesses earlier today to that point. Jack, talk to us about the stipulation of evidence, of documents, and why or why not you might do that as a defense attorney.
Oh, I think I might do that in a case like this. What stipulation really means is there's an agreement from both sides before the trial even starts that basically says, we'll agree that this document is what we say that it is, and we'll provide it to the fact finder, we'll provide it to the judge, so you don't have to actually get it into evidence. It's already agreed upon. I mean, the alternative really in this case is you could actually change the form of the question and say, there's a lot of preliminary stuff here, Your Honor. We're gonna go through it in a leading fashion. And because it's preliminary, I think the judge would be fine with it. A defense counsel probably wouldn't care either. So in other words, you could say to the Penske guy, I'm showing you a document. This document shows the rental of the truck. That rental of the truck was on this date. It actually went from here to here. It was this many miles on it, and you got paid this much. Did you get paid? And then you go straight at the question, you sit them down, you get it over with, you move on.
And I think it really shows the pivot that we all have to do as trial attorneys. Sometimes if you're used to trying cases in front of a jury, you really do have to pivot to change some of it before the judge on a bench trial. All right, we're going to continue to monitor the Hardin trial, but we want to shift gears to our other big stories next. Murder charges are reportedly on the way for the disgraced lawyer Alec Murdaugh. Our esteemed lawyers Jack and Mark will help us break it down. Also, more on the breaking news in the Depp defamation trial. The judge has ruled on Amber Heard's motion for a mistrial. We're going to talk about the decision and whether or not it was a correct one. Stay tuned.